application of Stott against Secretary of State for Justice.
Mr. Southey, it appeared to us that in substance this is really the government's appeal, and that you should be responding to whatever they throw at you in support of the status quo. But having read the Divisional Court's judgment, they would have been on your side were they not bound by the decision in Clift. And so unless Mr. Eadie feels completely thrown by what I have just thrown at him, because I apologise, we only discussed it just now, I think, and unless you have any serious objections, that's the right way to handle the argument.
No, and indeed, yesterday as I was preparing, or earlier this week when I've been preparing, the same thought crossed my mind, which in fact is obviously to some extent why we put in a supplementary today. So essentially responding.
Yeah. Thank you. Mr. Eadie might just possibly like something to put his papers on.
Yes, I forgot them.
And my apologies for the late start, which, as you know, has been caused by the rapid turnover in Lord Chancellors in recent months. And if you need the extra 10 minutes between you, you may, of course, have it at the end of the day.
I'm assuming, the only slight element of throwing is I'm assuming that you will have read at least some of the base materials. Yes. The judgment below, the judgment in Strasbourg, the previous judgment of the House Court in Clift, and so on. So I was proposing to look straight into the submissions. You're going to make submissions under three heads. And it's important, I will be submitting, that the analysis does actually follow the Article 14 sequence, other status, analogous situation and objective justification. But as is evident and as this court will be well aware, there is significant analytical overlap between those stages of the analysis, including in particular between the stages that deal with analogous situation and objective justification.
Absolutely, as indeed Lord Nichols pointed out in the Carson case, I think it was. He sums it all up in one sentence.
He does, and I came across another divisional court case called Foley, in which I note that the Secretary of State had himself, still himself at that point, been advocating the single question. I think it was very similar to the question that Lord Justice Morris Cave has posed. But that question, if I have the same...
Well, are the situations so similar that a difference in treatment of those situations requires justification?
Quite so. But Strasbourg, as we will see, has split out the stages and has considered them separately, so I'm proposing to do the same despite that overlap. And the key at all stages, or a key at all stages of the analysis we submit, is to recognise the following features. We're here dealing with primary legislation. That legislation prescribes a sentencing and release set of packages. Those packages are applicable to particular types of offending/offences. And the basic three categories, of course there are nuances, prisoners of special interest, the EDS scheme and so on. There are three basic categories: determinate sentences, extended determinate sentences, or EDS, and indeterminate. And the choice between those three basic categories in any particular case is, of course, for the sentencing court, depending upon the particular circumstances of cases coming forward. Those three basic categories and the legislative provisions that govern them are the subject of extensive and helpful explanation and analysis in one case in particular, with the Lord Chief Justice Thomas at the helm, in the Burinskas case. I'm not going to turn it up now because there's a large section of the judgment which deals with the relevant legislative provisions for each of those three basic categories and also considers the release provisions applicable to those. Burinskas is in Authorities Bundle 2, tab 17, at MS page 942. And as usual, I'm going to give you, I'll give you page numbers. It's going to be to the MS numbering, if that's acceptable. So you've got those three basic categories with the legislative provisions that apply both in relation to sentencing and in relation to release, summarised in Berinskas. But my submission will be that for the purpose of the Article 14 analysis, the various components of the packages in those three categories can and should be viewed together as integral to the disposal of particular cases. But what I don't intend to do in the oral submissions is to traverse again the basics of the regimes. Those are pretty much set out in Berinskas, or the differences between them and all the various nuances. We've dealt with that extensively in writing in our case, and I'm going to take that as read, if I may, and turn straight and first to other status. The issue arises in relation to other status on the basis that the European Court of Human Rights, a section of that court rather than the Grand Chamber, took a different view on the question whether, on the facts of the Clift case, the ground of the difference of treatment was other status. Took a different view to the House of Lords. And the questions which therefore arise are whether the European Court's judgment in Clift dictates an outcome on the other status issue in the present case. That itself poses the sub-questions as to whether or not Clift is distinguishable, and the broader question as to how wide is the reasoning and are the principles set out in Clift ECHR. And it also raises the broader domestic constitutional issue as to whether or not this court, taking the fourth section judgment into account, considers in effect, if it does consider that it's otherwise within Clift, considers that the dialogue, I summarise a well-known body of case law, whether the dialogue is at an end and Clift ECHR should therefore be followed. And there are obvious links to some extent with the answers you give to the first little set of questions I gave. The tighter confined the explanation of Clift is, the lesser is the broader significance of the issues in this appeal. But if one is into the assertions by the appellant here of, in effect, a very broad logic flowing from Clift, it may be that the court will take more persuasion that the fourth section intended to, or did, effect a fundamental and important change of basic approach or principle. And there may therefore be greater reluctance to go to that place unless the Grand Chamber itself has indicated that the principles are of that broader ilk. Can I start with the core principles and pick up under them the various areas on which there was some disagreement between the House of Lords and the European Court? The first core principle which we submit is in play is that it is not every difference of treatment that falls within the scope of Article 14. We say that principle is unaffected by Clift, and in principle it is right. The structure and the express terms of Article 14 make it plain, we submit, that it isn't every difference of treatment that falls within Article 14. In particular, if other status was intended to be a catch-all list, then the specified grounds would be pointless.
Yeah, why bother listing them?
Why bother listing them unless?
If any difference in treatment.
Right. The difference of treatment has got to be on one of the specified grounds or on the ground of something that can properly be characterised as other status. It's an article which, in this respect, if I'm allowed to crib from my lady's judgment in AL Serbia, at paragraph 26, Authorities 2, tab 10, page 716, is open-ended but not endless. But the European Court have positively and consistently, we submit, espoused that fundamental notion that the Article 14 grounds are not, to use my lady's word, endless. Not all differences of treatment. See for that purpose Clift in the European Court of Human Rights, Authorities, Volume 1, Tab 3. Check that reference. Yes, Volume 1, Tab 3.
It is.
650. Thank you. See Clift at paragraph 55, and confirmed more recently in 2017 by the Grand Chamber in Cam Tok Hugh.
How do you spell that?
KHAMTOKHU and Turkey at paragraph 61, and that's in Authorities Volume 5, Tab 57, MS 2150. So that's the first basic principle. Not every difference of treatment, open-ended but not endless other status. Secondly, we submit, in terms of the principles, other status sits, you will have noted, at the end of the list of specified grounds. And structurally, we submit that strongly implies that it was intended to operate a justem generis. And the meaning of other status and or its application should therefore be shaped by the analogy with the specified concepts. Thirdly, it was no doubt that thinking which shaped the identification of the concept that we maintain still lies at the heart of that grouping, and by that grouping I mean the specified and other status, namely personal characteristics. And again, as you may be aware, that concept was considered in a short but now often cited judgment of Lord Walker in the RJM case. Can I just invite you to take that up, principally because it's short and easy for those who may not have seen it recently. It's Authorities Bundle 4. Tab 37, MS 1451. So, Bundle 4, Tab 37, MS 1451. The context and headnote don't matter terribly. The paragraph for our purposes is probably paragraph 5 on MS 1458. This is where the simile of concentric circles is to be found. Can I just invite you to read? I'm very happy to read out if you'd like me to, but it's probably as easy for the court to just remind themselves of paragraph 5 on page 1458. There's the basic simile flowing from an identification from the Judson and Denmark case that personal characteristics is the core, at least, of other status.
Of course, what he was talking about was the degree to which a difference in treatment required to be justified. You know, if it's in the inner core, you need particularly serious grounds to justify it. The further you get to the outer, nevertheless it falls within other status, but nevertheless it is much easier to justify. That's what he was talking about.
My lady, yes, I think with respect he's doing two things. He's using the simile of concentric circles, which carries with it, at least, the implication that there is an outer circle. There is an area beyond the outer circle. What he's in part trying to do is to identify what feature, and we would say correctly identifying a justum generis, what feature that lies at the heart of other status. And he uses the concentric circles analogy for that purpose. So, but that implies that there is an end to the circles.
Well, I don't think it's in dispute that we're not dealing with endlessness, is it?
Well, there is a question about that, and there is a question about how far one goes, but at least concentric circles implies an outer limit.
Yes.
But my lady is entirely right. The second thing he's
Basically
doing
what he was on about, yes.
is to say the closer you are to innate, the more justification will be required. Again, a familiar approach and concept. So at the core, the most personal characteristics, as Lord Walker puts it, you have the characteristics that are innate, or as he puts it, innate and closely connected to an individual's personality. The other status concept is not necessarily restricted to that, and so one can be, in the outer circles, more concerned with what people do and what happens to them rather than who they are. If one uses that difference or distinction. But nevertheless, that concept of personal characteristics at least shapes or informs, we submit, the limit. And it does so precisely to hold true to the analogy with the other specified grounds and to avoid endlessness. And one should generally concentrate on what somebody is rather than what he or she is doing or what is being done to them. I take that phraseology from Lord Neuberger's judgment in the same case at paragraph 45. See between B and C on page 1469.
Well, what is being done to them is generally the treatment.
It is, and I'm going to come to that element in a moment. We respectfully submit that personal characteristics remains important and is a principled point of reference, because definitions as to precisely what other status covers are not easy to find. One may need to examine just how far personal characteristics can be stretched by reference to decided cases and examples. The question that Clift ECHR has raised, with its reference in the mantra which you'll be well familiar with, of personal or identifiable. I'm going to come to identify three particular mantra that Strasbourg used, both before and in Clift and thereafter. The formulation in Clift was personal or identifiable, and the question that posed, that formulation or that mantra posed, whether or not that had reduced other status to vanishing point. So though my Lord Hodge says correctly that I think no one is asserting endlessness, are we in effect there is the question that is posed by a formulation of that kind. And the possibility that other status had been reduced to vanishing point was a possibility specifically and expressly raised by Lord Mance and Lord Hughes in the Kayam case, K-A-I-Y-A-M, at tab 30 of volume 3, and the relevant paragraph raising that possibility is paragraph 52. at MS 1280.
It wasn't directly in point in that case.
And a similar question, had it been reduced to vanishing point, do we need to really bother about other status anymore? A similar question is in effect posed by Lord Wilson in the Matheson case at tab 36 in volume 3, and the relevant paragraph in which he poses the question is paragraph 22, page 1439. And by submission in answer to that question posed is that it hasn't reduced other status to vanishing point. It hasn't done so and shouldn't be taken to have done so in principle, precisely because the text of the provision is deliberately not endless and deliberately links back to, in terms of its structure and wording, links back to the concepts that have been specified in the article itself. And the European Court's jurisprudence has acknowledged that a difference of treatment must be on some recognised ground, so it isn't endless. See the cases I cited earlier, including Clift itself at para 55 and Kamtoku at 61. And even on the Clift formulation, personal characteristic in the sense identified and sought to be explained in RJM is still in the formulation. And it is well established, as we'll see in a moment, and an integral part of the Strasbourg jurisprudence on other status, that all of this reasoning, all of this identification of what other status actually encompasses or means, what its primary indicia are, all goes back, sometimes through Carson and the United Kingdom, but always goes back to Kjelsen and Denmark, which is repeatedly still cited. The relevant part of Kjelsen and Denmark simply refers to personal characteristics. As I say, there are some different formulations of the mantra that have been adopted since Kjelsen and since Clift. So Clift did it on the basis that the relevant mantra was personal or identifiable. There are some other cases, including Kamtoku, the recent Grand Chamber case, which frame the mantra as being, quote, identifiable, comma, objective or personal characteristic or status. Right, by which groups or persons are distinguishable from one another. That's Authorities 5, tab 57, 2150. But if one just simply takes that up as a recent Grand Chamber authority, bundle 5, it's paragraph 61, the one I gave you earlier on page 2150.
Well, they say it's not limited to innate or inherent characteristics.
Yes.
But they maintain the personal characteristics.
They do. They do, unless one reads the or in line 2 as disjunctive. It's a pretty peculiar formulation. I'll come back to the potential difficulties with that. But for present purposes, you will see that the cases cited are Clift, Carson, and Kjelsen.
Well, there wasn't really a problem, was there, in that case? It was sex and age, wasn't it?
Exactly so. But the formulation in Kjellson, we're spending a little time on this. If one goes back to Kjellson, that's in volume 5, tab, it says volume 5, tab 58. It may be miles old, but I think it's in volume 6.
Yes, sir.
Tab 58. I think the index may be a bit faulty in that respect, but the relevant paragraph they keep citing for this purpose is paragraph 56.
Page?
Page 2228. Starts on 2227. You'll see the Kjellson formulation is just personal characteristics. My lady rightly points out there was no doubt about it there on the facts, but I'm interested in the way in which the mantra is expressed and what one can draw from a different form of mantra. But there, Kjellson is pure personal characteristic. Go back to volume 4 into Carson. Or tab 48 in volume 4 is Carson. And the relevant paragraph for present purposes, sometimes miscited in other cases, whether it's the law reporter's fault or Strasbourg's fault is not entirely clear, but the relevant paragraph is 73.
Sorry, where is this in full?
Volume 4, tab 48,
Yeah.
1759.
Thank you.
This uses the other mantra. So we've seen the Kumtoku mantra, one's seen the Kjellson mantra, and now in Carson we get a slightly different formulation. Look at the second and third lines.
Sorry, could you remind me what the number was?
Yes, I'm so sorry. 1759. It's para 73.
Thank you.
Here the mantra is an identifiable characteristic or status. So it looks like it's treating identifiable characteristic as an equivalent to or alternative to, quote, status. But look at what the case that is cited, footnote 31. It's Kjellson, para 56, which we've just seen. So when you get to Kumtoku, Grand Chamber, it cites Carson and Kjellson. So you've got the different formulations of the mantra, but they're always citing Kjellson. And it doesn't look as though they're using those different forms of mantra, suggesting anything different.
So is it your position that Kelson still rules then?
My position is that Kjellson still encapsulates the core
Yes.
of other status. That's what it's going to be. But it's important to show you these forms of mantra. As the suggestion may be made, well, there they are. You see they've moved away from personal characteristic and they don't do that any longer. And that was what led to the question being posed by Lord Manson, Lord Hughes and Lord Wilson.
Yes.
Has it reduced the vanishing point? Because it's just anything that identifies different groups. Just to take a couple of 2 or 3 other cases shortly, if you've still got bundle 4 to hand.
Of course, Carson was about both age and place of residence, wasn't it?
It was principally residence.
Well, that was what.
Yeah.
But one of it was 2 cases, wasn't it?
Yes.
Yeah.
You're right, I'm sorry.
It's helpful, I think, always to remind ourselves what was the
what's the
suggested
grounding
characteristic
question? Yes.
in the particular case.
Yes, because sometimes there's no
Yes.
doubt about it at all.
Yeah, well, Cajelson was religion, that's obvious.
Yeah.
And habitual residence was not so obvious, but they held that it was.
Yes. And I'm going to come at the end of this analysis to some prisoner cases rather more directly, but this is just on the general principle and the formulation of the mantra, and whether anything truly flows from or can be implied from that. Just on the identifiable characteristic or status formulation of it, if you go to bar in the United Kingdom in the same bundle, tab 43, no, that must be wrong, tab 44, 1629, and the relevant paragraph for this purpose is 36. This is a judgment of a section of the court, including Judge Bratza. Para 36 is the one that deals with this. And you'll see it uses, again, the formulation of an identifiable characteristic or status. And again, footnote 11 cites Cajelson. Bio and Denmark, same bundle, tab 45, the next tab. This time Grand Chamber.
So what was the identifiable characteristic or status in?
Immigration status in bar. So I'm just checking what it was in Bio and Denmark. Paragraph 89 is the treatment of the thing in principle. And you'll see again,
I think that had an immigration connection, didn't it?
yeah. That's again identifiable characteristic or status, as you see from para 89 at 1682. Again, this becomes a little bit more complicated in relation to the footnotes, but you will see that what they've done is to set out the identifiable characteristic or other status test in para 89 first sentence. Then they've moved on to a difference of treatment in analogous or relevantly similar situations. And then there's a single footnoted citation at footnote 17, and that refers you back to Carson, para 61, and to Burden and the UK. Carson, you will recall, referred itself back to Cajelson and personal characteristics, and para 61 is the one we've looked at, which deals with other status.
It also refers to Kelson itself.
Also refers to Cajelson itself. Then, most recently, Fabian and Hungary. This is one of the authorities in you should have that in the supplemental bundle of authorities, Grand Chamber decision as well. It's behind tab 5, supplemental MS, page 89. The relevant paragraph for this purpose is 113. On supplemental MS 118. You'll see about, just by the whole, you probably haven't got a whole bunch, about half, just over halfway down the paragraph. However, not every difference of treatment will amount to a violation of Article 14. Firstly, the court has established in its case law that any differences in treatment based on an identifiable characteristic or status are capable of amounting to discrimination within the meaning of Article 14. See Carson, and then for good measure they cite a Weeder. But Carson, para 61, which itself, as you recall, referred back to Cajelson. So that's the basic case law on other status and on personal characteristics. And you needed to see those. I hope it's helpful to have taken you, if only quickly, through those, because the question was posed in the light of the Clift formulation, as I say, by Lord Manson, Lord Hughes in Kyan, by Lord Wilson in Matheson, as to whether or not that reference to personal or identifiable, and we now know that the mantra has moved from Cajelson personal characteristic alone to personal or identifiable in Clift to identifiable, objective or personal characteristic or status, and now is more regularly collapsed into identifiable characteristic or status. So those are the various formulations, and my submission is that on the back of that one needs to be extraordinarily careful before reading too much into the literal meaning of any particular one of those formulations. There are different forms of words, different mantra out there. And the one thing it appears tolerably evident from the case law with its repeated citation of the same cases is that they are treating those formulations as being in essence the same thing.
Well, it's possible to read the phrase, an identifiable characteristic, comma, or, and then in inverted commas, status, as the words or status simply meaning that's what we mean by status for the purposes of Article 14.
Exactly so. So the question then becomes whether
what's an identifiable characteristic?
What's identifiable, exactly so. But and the real question, I suppose, is whether or not by using that formulation they have in effect stripped out personal characteristic as lying at the heart of that, and whether construed literally, which I'm sure is what led to the question, the word or means that the concepts have got to be read disjunctively. My submission is not, that my lady's explanation is by far the better one. The new mantra, if one wants to approach it in that way, take account of the fact, which is accepted, that it doesn't need, and was accepted from RJM onwards in our domestic jurisprudence, that the personal characteristic or the identifiable characteristic doesn't necessarily need to be innate. But my submission is that personal characteristic and what that encapsulates, and the sort of analysis that one sees in, for example, the RJM judgment and the judgments of both Lord Walker and of Lord Neuberger, personal characteristic is and remains at the heart of it, as long as one understands that that doesn't necessarily restrict it only to something which is innate. So I'm sorry, that was rather a complicated way of seeking to answer that question, but as I say, the question had been posed entirely understandably given the change of mantra. But once one traces it through and takes into account the later case law, it's evident what is actually taking place, I submit.
Are you going to take us to any cases in which Strasbourg has said that Article 14 does not apply because the ground of the difference in treatment was not a status?
Yes, I am.
Good.
Prisoners.
Well, that would be very helpful.
Can I, just before seeking to do that, go to the fourth of the core principles, or the fourth of the contentious general principles? I hope you'll understand why I'm doing that. We're now at the top level of court here, and there is concern, obviously, as to other status and its meaning, which has ripple-out effects into a lot of other areas. If it's truly collapsed into nothing or disappeared to vanishing point, that's quite an important general thing. So it may be important to just finish the analysis with this fourth point. My submission on the fourth point is that the same thinking about remaining faithful to the analogical approach under Article 14 and avoiding potentially endless grounds, so undermining the limitation on the grounds in the structure of Article 14 itself, has led to a further principle. And that, we submit, is that the personal characteristic must exist independently from the treatment complained of. And the reason it must do so, personal or identifiable characteristic, must exist independently from the treatment complained of, because otherwise the ground becomes self-defining and the limit is destroyed. it's a bootstraps point in essence, and that point was made by both Lord Hope and Lord Bingham in Clift. See, for that purpose, Authorities 1, tab 2, and Lord Hope is at paragraph 45. Authorities 1, tab 2, paragraph 45 at page 628. Essentially, a similar point is made by Lord Bingham. If you go back a few pages to 623, and go to paragraph 28. That is a principle which continues to have at least domestic legal attraction, and one can understand why the principles I gave, but it continues to have domestic attraction. If you put away volume 1 and take up volume 2, and go to the Doherty case, behind tab 20, starting at 979, this is this is a judgment, I think, in December 2016, reported in the 2017 weeklies. So it postdates Clift and the ECHR. The relevant paragraph for our purpose is 63 in the judgment of Lord Hughes, with whom all other members of the court agreed. Between E and F in particular on page 1004, assuming for the sake of argument that status as a prisoner subject to a particular regime can in some circumstances amount to sufficient status to bring Article 14 into question, it cannot do so if the suggested status is defined entirely by the alleged discrimination. That was not the case in Clift. For that reason, the second suggested status cannot suffice.
You're going to come to what the European Court said about that submission.
Yeah. I'm going to come to it directly. Tab 3 in Bundle 1. The relevant paragraph is 60 on page 652.
We haven't got Porlick, have we?
We haven't got Porlick in the bundle. We haven't.
I mean, I had a quick look at it. It seemed to be a case, what is about paternity, I think, and different ways of proving paternity. And as far as I can see, the issue of status wasn't
Really raised.
No.
It's a difficult paragraph anyway, it might be thought, because it isn't clear how far they're going. It queries the government's reliance on the principle as a thing which is always to be satisfied. But looking at it from the other end of the telescope, as it were, they can't have been espousing and were not espousing a principle that the grounds could always self-define by reference to the treatment itself, because that would create endlessness. That's the identifiable objective that formulation of the mantra was that led Lord Wilson and Lord to query whether it had gone to nothing.
It seems to be quite an important part of the court's reasoning in Clift. I mean, you're saying it's wrong, are you?
Well, I'm saying that all they did was to query. They queried, not persuaded the government's argument of treatment of which the applicant's claims must exist independently of other states upon which it's based. So they're querying how far it goes, but they are not going to the other end. They're certainly not saying you can self-define because other status remains important.
But they go on to a different point, which is making sure that the rights aren't illusory, which is perhaps not, doesn't really answer the point. I mean, it might be useful to have Paulick, just simply because that's the only case they cite
Yes.
to illustrate the point, and on a quick look at
We'll certainly get that. We'll certainly get that, my lord, but you've floated it gently, and can I pick up the gentle flotation, as it were? It's not a very satisfactory alternative that is proposed, it might be thought. If there is doubt about how far they've gone with it and whether they're espousing some new principle, because all they actually do is to say, well, it all depends on all the circumstances and it's got to be practical and not illusory. Well, no doubt you take all the circumstances into account, and no doubt it has to be practical and not illusory. That's a well-established principle of general convention jurisprudence. But the unsatisfactory nature of those as tests is that they provide absolutely no indication whatever as to what it is in principle that is likely to make the difference. What is it that will define other status? And you can't just have a completely kind of open-ended thing, otherwise you risk precisely the problems of principle that I identified, namely that it just becomes a bootstraps thing. You just say, well, I'm different from the other person because of the treatment that's being meted out to me. And it may be that sometimes there might be a case in which the treatment doesn't exist independently, but there is nevertheless other status involved. It might be conceivably whether Paulick is that example, it might be possible. And so the concern they may have is whether or not one should always insist on that. But what they're on no view doing is going to the other end and saying you can just simply self-define by reference to the treatment. And it may be thought that the better view of this paragraph is that they are simply querying whether that is always required, and not necessarily closing the door on the possibility that there may be coincidence. But my respectful submission is that in almost all cases, if not all cases, that point, which has consistently attracted the domestic courts for good reason of principle, I submit, is and should remain an important part of the thinking about other status. And you will bear in mind that this paragraph in Clift, I don't think finds any other support or taking forward in any of the Grand Chamber decisions before or after Clift. So if you're thinking in terms of dialogue and how clear it is and how far the reasoning goes in general terms, we would respectfully submit that this paragraph is intensely problematic. It on no view is support for the principle that you can simply rely upon the treatment and that's the end of it, because otherwise it would be endless. And that's inconsistent with what they themselves said in Clift. The question is how far it goes. My submission is that the better view of it is that it's simply designed not to shut the door on that possibility. And the concerns don't end there if what this is actually doing is to set some different test, as it were, from the tests which have attracted the domestic courts. It's not doing, if I may respectfully say so, a terribly helpful job of it, because simply referring to all the circumstances doesn't assist one to draw the lines that are required in this context. Can I turn to some 3 prisoner cases, if I may, on this area? The first is Gerger and Turkey, a a Grand Chamber decision, Authorities 5, tab 54. Page, starts at page 2005. Key paragraph is paragraph 69.
Paragraph.
Paragraph 69.
Thank you.
The context of the case was that a person that was sentenced under a particular law to do with terrorism was entitled to automatic parole at 3/4 time and not half time being applicable to other prisoners. Got similarities or parallels with one case. The reasoning under Article 14, you see set out 69 on 2032. Court notes, I'm reading from the second sub-para, the court notes that in principle the aim of law 3713 is to penalise people who commit terrorist offences, and anyone convicted under that law will be treated less favourably with regard to automatic parole than persons convicted under the ordinary law. Deduces from that fact that the distinction is made not between different groups of people, but between different types of offence, according to the legislature's view of their gravity. Court sees no ground for concluding that that practice amounts to a form of discrimination that is contrary to the Convention, consequently no violation of Article 14. So a distinction is there drawn between different types of offence, according to the legislature's view of their gravity, and different groups of people. We say it's plain from that they are dealing here with the concept of other status and drawing that distinction, because that's plainly the relevance of the analysis that they set out in 69. So that's the Grand Chamber case of Gerger and Turkey. Budak, go back, sorry to jump around, but it's constantly alphabetical sequencing. Budak is in Authorities Volume 4. Tab 47, 1732, so 447, 1732, Chamber judgment on admissibility. Sir Nicholas Bratzer in the chair. And the relevant paragraph for our purposes is paragraph 4.
Page?
Page 1735, sorry, my lady. Here you're dealing, as you see from paragraph 4, with an allegation of discrimination because the criminal procedures and sentences for offences tried before the State Security Court were different from those in respect of offences tried in other courts. The Court reiterates that Article 14 is not concerned with all differences of treatment, but only with differences having as their basis or reason a personal characteristic, brackets, status, in inverted commas, by which persons or groups of persons are distinguishable from each other, cites Kjelsen. In the instant case, the distinction was not between different groups of people, but between different types of offence, according to the legislature's view of their gravity. And you'll remember that phraseology from Gerger. It's making it absolutely clear that that paragraph is dealing with other status. That's how the court has taken it. The court sees no ground for concluding this practice amounts to a form of discrimination that is contrary to the Convention. So exactly the same distinction that is drawn, directly applying the language and reasoning in Gerger. And then that can go away, and the final of these cases is Minter and the United Kingdom in Authorities Volume 6. So 6, tab 62, starts on page 2266.
What's the date of Budak? I mean, the application was in 2000, but the decision must be quite a lot later than that.
Yeah. Did think about this.
It says September 2004, 7th September. Fourth section, sitting on 7th September,
Yeah.
Yeah.
Yes, I'm grateful.
1732.
Yep.
Yep.
Thank you.
So Minter is bang up to date, 2017 May. And you see the context from paragraphs 4 and 5 on 2266, extended sentences, released on licence and so on. Then notification requirements you see from para 6. You see the factual context from paras 9 through to the end of 12. The reasoning of the divisional court encapsulated in para 16. Fifth problem referred to in para 18. The Court of Appeal's reasoning, Lord Justice Law's, encapsulated in para 21. And then the key part of the reasoning starts at 66. Cited Kantoku, para 66. Massey case, and I think is in the bundle as well, but we may come to it later. But it's like the Massey case at 67. And they address an argument based on Clift and other status, and the reasoning of the court in Clift on other status in 68. So the distinction that is being drawn is a similar one to the one that we've seen in the Gerger case and in Budak. The distinction between turns on the different treatment not concerning the length of the applicant's sentence, but rather the different sentencing regime applied to him in that context as a consequence of the legislation. It's clear from this authority, consistently with the ones I've taken you to before, that differential treatment based on a mere sentencing regime doesn't fall within other status. That's the reasoning, and they reject the analogy with Clift in that context. So on the basis of that set of authorities and of those general principles, can I try and tie together some conclusion submissions on other status, if I may? Firstly, we submit Clift is distinguishable. In Clift, other status was found on the following basis. It's a classification by reason of the length of sentence, contrasted with a classification based on the gravity or nature of the offence or the offending regime. And the court itself has specifically drawn that distinction in later cases. See Gerger and Budak and Minter. And the basis of that core distinction places on the side of not being within other status distinctions based on the nature and gravity of the crimes committed and or of the sentencing regime. So however logically satisfactory, the distinctions that they're drawing are between, as they put it, groups of people against different types of offence or sentencing regimes.
But it's interesting, isn't it, that what the court said in Clift was, because the obvious point was made for the government, not surprisingly, that the length of sentence did depend upon the gravity of the offence. To which, as I understand it, the court said, well, yes, but it also depends on other things.
Yes.
Well, that's our situation here, isn't it?
Well, my lady, the difference we submit is that, I mean, again, it's quite difficult to know precisely where the line is drawn, but if you look at those later cases, they are drawing distinctions we submit on the basis of a particular type of sentencing regime applicable depending upon the view of the seriousness of the offence by Parliament, to use that language. So it isn't exactly the same, and one can see, with respect, even if they don't quite put it this way, one can see why they had a potential difficulty on other status in Clift. But it's at least tolerably clear from that later case law, including the Grand Chamber decision in Gerger, that they do draw distinctions which place outside other status things that flow from the seriousness of the offending regime that the relevant local parliament has chosen to set up. That's a distinction which is based, if one takes it back to the core concept, not on anything to do with a personal characteristic at all, but simply on the basis of a different type of offence or sentencing regime. And again, if one takes it back to first principles, it falls very squarely in the what people do or have done to them, rather than falls on the, we submit, outside the concentric circles that were identified in RJM. The concern in Clift was that the differential treatment applied exclusively by reason of the length of sentence, irrespective of the offence or what the person had done. And that was due to a peculiar feature of the statutory regime. The distinction here is not between different groups of people, i.e. people with a sentence of 15 years or below or 15 years or above, but between different types of offence, precisely according to the legislature's view of their gravity, for reasons that I will explain. And that, we respectfully submit, is entirely consistent in terms of reasoning and approach borne out by the post-Clift authorities with what my lady said in the House of Lords in Clift at paragraph 62 and 63, MS 632. And moreover, again, to come back to base principles, the treatment complained of here doesn't exist independently of the characteristic on which he's based his complaint. The release conditions flow from his position as a person convicted and sentenced to EDS, given the nature of the offence. So the discriminatory treatment complained of is the very thing which is said to found other status. And that falls foul of the principle recently espoused by this court in paragraph 63 of Doherty that I took you to. So my first submission is therefore that Clift is distinguishable on those grounds and by reference to the ECHR case law. Secondly, and this slightly depends on what view one takes ultimately of all the principles that I took you through earlier, but there are real questions we respectfully submit about the extent of, at least on one reading of it, the reasoning in Clift on other status. it risks either providing no guidance at all, in all the circumstances, practical and not illusory, or worse, on one view, and again the devil on this may be in the meaning of the mantra, the various mantra that have been used, it risks reducing other status to vanishing point and rendering Article 14 and other status not merely open-ended but endless, the vice that my lady has identified. Thirdly, and this is again a submission of general principle, wherever precisely the line is to be drawn around other status, it has not, in effect, we submit, been removed by the fourth section's judgment in Clift. The suggestion appears to be made that any form of sentencing regime creates other status. There's nothing in the jurisprudence to support that, not even Clift. And on the contrary, for the reasons we've seen, in those three later cases, specific distinctions are maintained in the various prisoner cases that would be directly inconsistent with any such case. Moreover, the logic of that submission is intensely difficult and problematic, we submit. Every prisoner having other status just because they're sentenced. All prisoners would have that status. That would be a very significant extension indeed, engaging squarely the Ulla principle on the back of a fourth section judgment. We respectfully submit you don't get there because that's not the right reading of it, but if you were tempted to, the further out you go on that logic, the more problematic it becomes, the more Ulla is engaged. And there are obviously concerns that I've identified earlier about flow out into other contexts. The fourth submission is an alternative one. It's the one that my lady flagged when we were discussing the concentric circles and RJM. It is that even if we're wrong about all of that, this, if it does fall within other status, falls at the very outer edge of the outermost concentric circle, and for that reason will be, I summarise, easier to justify / attract a broader margin. That is the consequence of falling within those outer concentric circles, even if you're within. We saw from Lord Walker in RJM at paragraph 5, as he put it, MS 1459, the more peripheral or debatable any suggested personal characteristic is, the less likely it is to come within the most sensitive area where discrimination is particularly difficult to justify. That's all I want to say on other status. I'm afraid it's taken a little time. But can I turn to analogous situation? I'll make three general points in relation to analogous situation, three general submissions before turning directly to an analysis of analogous position viewed from the perspective of the application of the release provisions. But the three general points are these. Firstly, we submit that EDS, extended determinate sentence, is a specific sui generis custodial sentence designed by Parliament to address the particular combination of the seriousness or nature of the offending and the risk posed by offenders who meet the criteria for its imposition. It exists, therefore, as a sentence if the sentencing court, and it is the sentencing court, is satisfied that those statutory criteria are met and that the nature of the offending makes this the appropriate sentence. And it sits, if you will, betwixt and between determinate on the left-hand side and indeterminate on the right. And of course, if that is the decision of the sentencing court, that EDS is the appropriate sentence, by definition, other sentences, determinate or indeterminate, are appropriate to other situations and don't attract the particular combination and play of factors or criteria underpinning the EDS option. And no one suggests or could suggest that Parliament wasn't perfectly entitled to set up this sort of regime with this sort of sentencing package sitting between determinate and indeterminate, with the criteria laid down in the legislation, but leaving the sentencing court to decide which is the appropriate sentence off that menu. There are, of course, intricacies set out in our case, get released at slightly earlier than half-time and so on, but as far as we're concerned, those simply add to this idea that Parliament has set out a menu of options for the sentencing court in particular to choose from. The second general point is that the comparison is thus with sentencing regimes and all particular types of offence satisfying the statutory criteria and rendering it appropriate in the judgment of the sentencing court to impose this sort of sentence rather than another one. And that conclusion undermines the suggested analogous position we submit.
But what is the criterion that leads the court to choose between the differing sentencing options which are available for exactly the same?
Well, I'm going to come to that, but it's
to it when you wish to come.
In essence, it's dangerousness and seriousness of the offence. Those are in there. There's got to be a finding of dangerousness. So there are elements. The submission is going to be that there are elements, as it were, that Parliament has drawn from indeterminate. There are elements that Parliament has drawn from determinate. The basic underpinnings for all of those regimes flows through into this, but it's a specific package that Parliament has designed.
When the sentencing judge is deciding, he can't take account, am I right in thinking about, of the release consequences under the particular sentence he chooses?
You're right. He can't, and he sets the determinate sentence, then he sets the length of the licence period thereafter.
But he can't in this instance think, if I imposed a life sentence, there would be an eligibility to apply for parole at half-time, but on the extended determinate sentence at two-thirds time.
He can't, but as we'll see in a moment, the regimes are not uncomplicated. And when we get, for example, to life sentences and discretionary life sentences, the usual rule, for reasons which I will show you in a moment, is that it's the determinate, the bit that he has...
I've oversimplified, I understand that.
Yes, the bit that he has to serve is set at half-time, but the court has a discretion to set it at a longer period.
I understand that.
So there are nuances everywhere, I'm afraid. But
the basic proposition is he can't look at the release provision.
For the purpose of EDS, when he's setting the determinate part of it, no.
Well, that's correct, of course. But he can decide whether or not he's going to impose a simple determinate sentence.
Yes, he can.
Or an EDS.
Or an EDS, my lady.
That's the point I was getting at.
Yeah. My lady, I'm sorry, you're entirely right.
So what's the criterion? But you're going to come to that.
And can I just take you in this context of where the analogue is, what the difference is to the Massey case that we saw referred to in the Minter judgment of the Strasbourg court. That's in bundle 3, tab 35.
Is this part of your three general points, Mr. Eadie?
Still part of the second.
Part of the second. Thank you.
Which is comparator. Bundle 3, tab 35. And the relevant paragraph for our purposes is 25.
So this is supposed to be the Minter case, is it?
No, this is the Massey.
Massey case.
But it was referred to in Minter.
I'm sorry.
I haven't got time to go through all the
Right.
facts and the context, but the contrast is being... Contrast is in effect being drawn between life and an extended determinate sentence. And you'll see the reasoning of the court at paragraph 21. They're adopting, in effect, the package approach. You can't compare life with EDS, in effect. They rather duck the exists independently point as a result of Clift in para 23. And then you see the reasoning picked up again in 24. I must show he's in an analogous position to one who's sentenced after that date for a similar type of offence. Depends on the nature of his complaint and so on. And then 25. And then you see halfway down 25, 7 lines down, halfway through the line, the reality of his argument is that he was sentenced under a different regime. It's not coherent then to allege discrimination when compared to other offenders sentenced under a different regime. They're not in an analogous situation precisely because they were sentenced under a different regime. Claimant cannot complain because Parliament has now abolished IPPs and introduced a different type of sentence. The UK is not obliged under the convention to reopen historical sentences and re-sentence merely because it introduced a new sentencing regime. I dismiss his application on both grounds. Dealing there with a change to the IPP regime, so there was a new regime, but the point remains sound, we submit, and consistent with the Strasbourg case law, where there are various sentences with their own features to be considered and selected, that may operate to destroy the analogy. And the third of the general points is that the comparator crimes or sentencing regimes may have points of similarity in a general sense, dangerousness and risk in play, seriousness in play, in serious, determinate and indeterminate sentences, but that doesn't make prisoners sentenced to EDS. It doesn't place them in an analogous situation. It's the combination and the way in which Parliament has dealt with that combination of seriousness and risk, which isn't the same. Or they would have got a pure determinate or a life sentence. And my submission is that the EDS prisoners aren't in analogous positions with either determinate or indeterminate, viewed purely from the perspective of the application for release provisions. My first and perhaps core submission is that the release at 2/3 is bound up in the overall sentencing package provided for in the primary legislation. It's part of that sentencing package for this particular sui generis combination of seriousness and risk. And if one, this is perhaps the second point, if one looks at the legislative scheme overall, focusing on earlier release, what that indicates, we summarised it all in our case, is that there are a variety of combinations, even in relation to that, in relation to how different sentences deal with the various elements of sentence underpinning, punishment, deterrence, dangerousness, and so on. The early release provisions sit within that package or menu. And there are a wide range of differences, discretionary release provisions in the determinate sphere, different ways of approaching the minimum terms in the indeterminate sphere. So it isn't accurate even to say that all determinate sentence prisoners will be released or eligible for release at half time, or that you always get released at half time if you're indeterminate. Focusing first of all on the determinate position, or the comparison with the determinate position, our submission is that the EDS prisoner is not in an analogous position to determinate sentence prisoners. All EDS prisoners have been found to be dangerous. And EDS is the only determinate sentence with a determinate element in it, which requires a finding of dangerousness as a condition for its imposition. This combination of seriousness and dangerousness, in other words, the other statutory criteria, mark this EDS sentence and sentencing regime out as appropriate for those to whom the court decides it should apply.
Well, that sounds like a justification argument.
Well, my lady, I'm running through this on analogy, but justification is raised very similar arguments. They're not going to be terribly dissimilar when we get there.
You said there was an overlap between 2 and 3. Anyway, yes.
Yeah. And one can place these wherever you want, as it were, on the analysis. My learned friend said that EDS and determinate sentence prisoners are in effect analogous because the punitive or deterrent elements in non-EDS prisoners in effect cease at halfway. In fact, and in principle, the position is as follows. All determinate sentences are justified throughout their term, i.e. after halfway, as we know from all the recall cases, by the purposes of punishment and deterrence. So, for example, under Article 5.4, challenges are failed because the supervision required by 5.4 has been provided by the sentencing court. For the purpose of 5.1a, the detention is lawful throughout the period of the sentence, even if the person's been released and then recalled, for the same reason. I'm not going to go back through all those cases. You've considered them recently. They're summarised and pulled together in our case at para 62. But see in particular, analysing those cases, the Supreme Court's more recent judgment in the Whiston case, Authorities 4, tab 40, page 1539, especially at paragraphs 25, 38 and 43. And EDS, as we know, is comprised of a custodial term imposed for punishment and deterrence and the extension to the licence imposed for public protection. And if you want that analysis very clearly set out, see the very recent Supreme Court judgment in Brown and the Parole Board, the judgment of Lord Reed, paragraphs 58 to 60. That's in Authorities, Bundle 2, tab 15, page 872.
No one's suggesting there's any substantive difference between the Scottish extended sentence and the EDS in terms of principle.
No.
Yeah.
Exactly the same. And that analysis of Lord Reed sits directly. He breaks it down into the two components I've identified. But throughout the custodial term, and irrespective of the possibility of release early, you can continue to serve the period of imprisonment imposed by the court. And you get the same thinking in relation to Article 7, that's the non-retrospective imposition of penalties, so where the early release provisions change after the sentence has happened. The courts have had to consider whether Article 7 is in play. And in essence, the Article 7 case law establishes that there is a distinction between, on the one hand, the penalty, Article 7, and on the other hand, measures, such as early release provisions, that constitute the execution or enforcement of the penalty. So, in a nutshell, you can change the early release provisions during the currency of a sentence to push back early release without falling foul of the preclusion on retrospective penalties contained in Article 7. That's recently been the subject of consideration by the Supreme Court in the Doherty case. See especially on Article 7 for that purpose, para 19, Authorities 2, tab 20, page 989, and there the Supreme Court based itself on the earlier House of Lords decision in Utley, Bundle 4, tab 41, page 1558. Utley, as you may recall, had involved the introduction of release provisions on licence at the two-third point, as compared to the earlier regime. The release at that point was unconditional. That was held not to render the sentence more severe, and so Article 7 was not engaged. So we respectfully submit that his case, that the point of release or eligibility to apply for release equates to and marks the end of the punitive period is unsound. The court's consistent analysis has been to reject the analysis of determinate sentences as incorporating a penal element and then risk-based detention for the period after half or two-thirds, whatever it happens to be. The whole term is on the basis of punishment and deterrence. The early release provisions don't affect that. We respectfully submit that they're not, EDS prisoners are not in an analogous position to determinate sentence prisoners. In relation to indeterminate sentence prisoners, he's not in an analogous position either. It's to be noted at the outset of this, and I've flagged it already, but that the indeterminate sentence position is that the tariff period is not, under the statutory regime, always set on the basis of 1/2, which is really his point of comparison. He says 1/2 early release or 1/2 eligible for release as compared to 2/3 for EDS. If you take up bundle 2, if you would, and go to the Rossi case, bundle 2, tab 21, Lord Justice Fulford sitting in the CACD with Mr. Justice Wynne Williams and Mrs. Justice Simler. And the relevant paragraphs for this purpose, and this is in the context of sentencing, and how you go about dealing with the tariff period for someone who is sentenced to discretionary life. Look at paragraphs 20 to 23 on page 1011. The key is perhaps in 2020, it's in 20 and 22, but so as you see, the position is that the usual rule is that it gets set at 1/2, but that the court has a discretion to impose, as it were, a longer term in exceptional circumstances. And in that case, the exceptional circumstances, even though the judge fell foul of the need to set out reasons for setting a longer tariff period, there were held to be exceptional circumstances based on the seriousness of the offence, in a nutshell. So you can't assume that the tariff period is always going to be 1/2. The relevant regime allows for that period to be 1/2 or 2/3 or even longer.
But there is a norm.
There is a norm. There is a norm. But as I say, this is a provision of general application, and seriousness is an indicator of exceptionality, if I can put it that way. You should note, if you go to bundle 1 and you go behind tab 9.
It's quite interesting, though, isn't it, in paragraph 22, the reasons why they thought it justified to set more than the 2/3 had to do with his previous history, rather than the particular gravity of what he'd done this time.
Particular offence, yes. I'm not sure anyone has sought comprehensively to define what could amount to exceptional circumstances.
Well,
In this case, the authority of the proposition, you've got to set out the reasons to enable the appellate courts to grapple with that offence. The reason I wanted to go to tab 9 was to ensure that you at least knew what the legislative position is. tab 9 sets out the currently in force legislative position which the court there referred to. And you will see, in particular from 82A sub 3 on page 702, that when doing the when setting the tariff period, this is the exception to the rule my lady put to me in relation to determinants. You do take it into account for this purpose. It's all, I'm afraid, incredibly complicated, but you do for this purpose. And what this section is dealing with is how long. And you'll see that on the sections currently in force, the thing is left open-ended, in effect. The part of this sentence shall be such, I'm reading from 3, as the court considers appropriate, taking into account, and then it lists a variety of factors, including the seriousness of the offence. So it is for the court to determine whether it should be a half or 2/3 or something between or longer. The reason I wanted to go there is so you have the position completely to hand, even though it appears to be rather less satisfactory than it perhaps should be. We've got a section, a set of these provisions as enacted, which probably ought to be tucked in if they could be tucked in with tab 9. And the reason for going there, despite the fact that it's a long and complex provision, is that you will see that enacted but not yet in force, despite the fact that they were enacted by amendments passed as long ago as 2008, are a set of provisions which would or might otherwise assist the court and to provide some matters to be taken into account when deciding on what the length of that period should be. So you see that there have been enacted but not brought into force new subsections 3 capital A, 3B and 3C. Now, again, I don't want to trace through in any great detail what they are because they haven't been brought into force for whatever reason, and so they don't sit on the in-force statute book. But you'll see that that, in effect, with some limits, looks very similar or substantially similar to the sort of thing that the Court of Appeal did in Rossi anyway. But you'll see what my Lord Hodge described as the norm, it's right to point out, in 3 capital C. Final line before you get to 3 capital C little a. Instead of reducing that period by half, reduce it by some lesser amount. In other words, make them serve longer by way of tariff. But the grounds on which they do that are that the case is exceptional if the offender is over 18, C3A. That's to do with the seriousness of the offence or the combination of the offence and one or more other offences associated with it. So you've now got at least a statutory, unbrought into force but on the books, position which looks remarkably like Rossi. It goes to the same point, which is that you can't assume, albeit that that is the norm, that they will always be set on the basis of 1/2, those tariffs. The core point, perhaps, in relation to indeterminate, when you're doing the comparison between indeterminate and EDS, is that the discretionary life sentence again involves comparing different sentences applicable to different offences and offenders. For the criteria under the 2003 Act, see our case at footnote 74, but the package is different in relation to these sorts of offences. The regime is different. Life sentences are, as the courts have repeatedly emphasised, the most severe that the law can impose. And they have, for that reason, features that reflect that fact. In particular, that the prisoner remains liable to be recalled to detention for the rest of the prisoner's life. But also, because life sentence prisoners remain liable to serve the whole of that minimum term, the whole of that tariff. I can perhaps take that from the Berinskas case, if you've still got volume 2 there. If you go back to tab 17, this is the one I referred to earlier with the helpful summary of the relevant law. Lord Thomas, Mr. Justice Mitting, and she now is Lady Justice Thirlwall.
Sorry, can I have the reference again, please?
So sorry. Tab 17 in the same bundle, bundle 2.
217, yes.
And the relevant paragraphs for our purpose, and this has some relevance for the purpose of whether or not they are truly an analogous situation. The relevant paragraphs start at 35, and you'll see that what the court was there doing was to consider, sorry, page 952. What the court was there doing in 35 was addressing a submission by advocates who are considering, they're in effect considering when you should, what the conditions are for and when you should be sentenced to any of the 3 basic categories I identified: determinate, EDS, life. But you'll see that it was said in that case that there was an anomaly caused by the early release provisions. The effect is that the life prisoner may serve less time in prison than an offender serving the custodial term of an extended sentence, even though the appropriate custodial term is the same. And I emphasise the word may for reasons I've just taken you through. May or may not be. If it's considered to be exceptionally serious, then on the Rossi line, you could have more. These examples of offender A and offender B. And then they say in relation to that anomaly, we understand the argument, I'm reading from the beginning of para 36, but the position is more complex. And the reason is the reason I've given. A life sentence prisoner is not entitled to release at the end of the minimum term. He must wait until the parole board is satisfied. In some cases, the date is years after. Prisoner serving extended sentence is entitled to be released at the end of the custodial period without any further assessment of risk. Where the custodial period is less than 10 years, entitlement is at the third point, 2/3 point. And then you see the argument, 37. Can I just invite you to read to the end of 39 rather than my reading it out, and you'll get the point. But it's because of those differences that when sentencing, they have been considered to be different, unsurprisingly. And one gets that if you put Berinskas away, the point emerges from that. But if you go to the index, to the supplemental authorities, the small clip of those.
Can I just ask, bearing in mind what was said in Berinskas about the difference between the release provisions, one was simply an opportunity, the other was an entitlement. In the present case, what is the declaration of incompatibility as to? What is it said that there should have been, instead of an entitlement to be released at 2/3 stage, a possibility of applying for release involving, for example, the parole board at the half stage?
Well, my learned friend doesn't quite come off the fence on that. There's a general declaration of incompatibility sought in relation to these provisions saying 2/3. But my lord raises an interesting point, because when you get this sort of divergence with these complexities feeding into the particular package, it's as well, as it were, to think about remedy, because it does tend to bring to the fore quite what you would do.
We've got to decide in respect of what is the incompatibility.
Right, and what element, and how would you go about doing it?
Paragraph 52 of the Divisional Court's judgment Sir Brian Levison, it says, I would otherwise have been prepared to conclude that Section 246A of the 2003 Act limiting the eligibility for parole to a point 2/3 of the way through the nominated determinate term was incompatible.
Right.
That's what he thought.
Right.
And I was going to add.
And you were going to say, that's what you want.
That's what we want. If it was hard, if there was an opportunity to apply, and one had an entitlement based on risk at halfway point, we could not complain, and we accept that.
But then you have the potential difficulty that life sentences, if you're comparing them with indeterminate, can be set at some point other than halfway. So the comparison is not exact. I'm not saying it's conclusive, but it does illustrate my point about the package and the various nuances that sit within each package.
Yes, to make it parallel, it would have to be actually
Half, but if it was very serious, you take it forward.
an opportunity to ask the court when fixing the extended sentence.
And one can take the same point in relation to determinate sentence prisoners and all the variations and nuances in relation to that about possibility of being released a little bit before half time or not, as you've seen from the case.
It's not for this court to cure the incompatibility if there is an incompatibility.
It isn't, my lady, and I don't make that side.
It's for this court to identify whether or not there is one, and then it is up to government or legislature to put it right in whichever way they want. And of course, they can do things like level up as well as level down.
They can. That's entirely true. But what the remedial analysis does assist on is this package argument and the differences that sit between them. Because when you start saying, well, how do you achieve exact comparison? It brings to the fore, as it were, the subtleties and the nuances that sit within each of these packages.
It's not very helpful if we simply say to the government this is incompatible without saying in what precise respect.
Right, but then that takes you to how do you create the direct analogue, how do you create the thing that is unjustified?
There may be various ways of paralleling them, but one does at least need to identify
Which? How?
well, that exists, and it's not simply a question of substituting half.
Well, yes, I'm still on an analogous situation, and I wanted to make the point that you get from Berinskas anyway, that those differences between the indeterminate package and the EDS package have been treated as important when considering sentence for understandable and obvious reasons. And two cases, briefly, if I may. In the supplemental authorities bundle, behind tab 7, first of all, one has Rahim Abdul Saw, which is also the Attorney General's reference number 33 of 2016. Can I just invite you to write on it that is also Authorities 2 tab 12. The Authorities 2 tab 12, don't need to turn it up because that version, the paragraph numbers have gone completely awry. And so the references to paragraph numbers in this authority in our case at para 97 are unintelligible. So this is the better version. So para 97, we said, see this authority at paragraph 43, but in the version that you had in the original authorities bundles, the paragraph numbering had gone awry. So
Sorry, I'm actually lost at the moment.
it's
supplemental
tab 7, MS 153 it starts.
Yep.
And the point you're wanting to draw to our attention?
It is that it is at paragraph 42 and 43, really. So they cite Berinskas, they're toying with the choice between life sentence and EDS, and in making that choice between the two packages, they highlight the difficulty or the difference between the regimes, the distinction between the regimes you see in particular at 42. Can't apply for release before the end of the punitive term, appropriate custodial term, and so on. And the same arises in relation to the other key difference between these regimes in the authority at the previous tab 6, MS 146, divine, And again, if you write on that, that used to be Authorities 2, tab 19, it's been replaced for the same reason. Paragraph numbering went awry. And the relevant paragraphs for present purposes there are 31 and 32. And there the submission is made that a life sentence is less serious than an extended sentence. Therefore, the court can and should substitute a life sentence for the extended sentence that was passed. So for the purpose of sentencing, slightly, not sure what advice the prisoner received before that submission was made, but the court regarded it as a surprising one for obvious reasons. And you see in para 32, they said, they're focusing on the fact that the prisoner who is sentenced to life is subject to recall throughout the rest of their lives. So the other key distinction. But for the purpose of sentencing, therefore, these regimes are treated as, these particular points of distinction between the two regimes are treated as being important, and that reasoning transfers over into truly analogous for the purpose of Article 14. It's also to be noted, and again, this is the final point on analogous situation, that the criteria for some life sentences, at least, do require dangerousness. Most of them do require dangerousness, but some don't. As the court in Berinskas pointed out at paragraph 8, 224A prisoners may not be dangerous. That's those who committed 2 offences of the particular scheduled kind. So that's analogous situation. I turn finally to objective justification. I'll deal with that briefly because many of the points have been made and are transposable, as it were, between the analytical stages.
Can I just interrupt to ask you, whilst we've still got the Divine case open, and it's stressing that a life sentence is more serious than an extended determinate term, whether there isn't a tension about this? Because in terms of the period spent in custody, if the same amount was fixed, it would be necessarily the difference between a half and 2/3 if it was a half provision in the life sentence. And some prisoners might think that the period you spend actually in custody is quite a penal element in their sentence as opposed to the time that they spend on licence. So there's a slight tension in this description of the life sentence being more serious.
My lady, yes, and that is the essence of my learned friend's case. My submission, as you will now well appreciate, is that you regard these different sentences as a package. And if I can put it this way, it's probably not the right way of putting it, but if I can put it this way, the 2/3 sentence is an integral part of the EDS provision, but you don't get either of the, from the prisoner's point of view, vices of the life sentence, namely the 2 features we've just been identifying. The trade-off for getting 2/3 on the determinate part before you can apply is that you don't end up on licence for the rest of your life. And moreover, you are entitled to be released from an EDS sentence on licence for the extended period. Entitled to be released automatically at the end of that determinate sentence, and that is not the position, as the court pointed out in Berinskas, in relation to life.
But if the risk, in fact, is demonstrated to the parole board to have disappeared, or sufficiently disappeared, at the halfway point, being very simplistic about it, on the life sentence, they have the opportunity of coming out.
They do, and that is a different.
On one view of it, Parliament's taken the view that everybody who's on an extended determinate sentence, the chances of them being ready for release at in the half to 2/3 point are so minimal that option isn't there.
Well, it's a combination. We know that in all sentencing, and particularly when you divide up the elements, there are those features that are punitive/deterrent, and there are those features that are to do with dangerousness. We know that all EDS prisoners have to be found to be dangerous. And there is at least a question, which is unresolved on the face of the legislation at least, as to whether or not the 2/3 early release, which is part of that package, is referable to the one thing or to the other thing, or to a bit of both. In other words, but my submission is that you look at the package overall. So true it is that you could have the sort of case that my lady identifies, and of course that is the position, that is the consequence. Half not dangerous, lifer release because the parole board say so. But you look at the package as an overall package of measures for the purpose of Article 14 and ask whether Parliament was entitled to make the judgments that it did. It's legislated on a broad basis, and as I say, for the purpose of the EDS prisoner, 2/3 early release can't be divorced from the favourable features for the prisoners as compared to lifers. I jumped ahead of myself because those were essentially going to be, they're going to be the submissions on objective justification. But if I can take them more quickly, it was helpful to have the debates the only way to do that. But let's just do the stages. Objective justification. My submission is that Parliament is entitled to set different regimes operating in different ways with all those nuanced features in this sphere. There's no requirement for uniformity or equivalence in relation to early release dates or any other component. And in part that is because it's well recognised that they have a wide margin in setting up criminal sentencing and a wide margin in setting up early release provisions. And that breadth of margin, or ease of justification, if you will, is particularly so given that we are, and this is the link between the various analytical stages, at the very most, the outer concentric circles. And we are here dealing with sentencing policy at the level of primary legislation. Of course, the schemes have points of difference, and of course they have points of similarity. But at base they represent, we submit, different regimes as a package, most of which involve the sentencing court, some of which are laid down like the 2/3 point in primary legislation, depending upon the particular offences and offenders who are being sentenced. And one needs to view the sentencing and release provisions as a package. For Article 14 purposes we submit. So what's the objective justification in relation to determinate sentence prisoners and the differences between EDS and those? And the key point of difference is that EDS prisoners are judged to be dangerous. There are special provisions applicable to them, including licence conditions after the custodial term, but the special provisions also include, for Article 14 purposes, the release provisions and the differences that exist between the 2/3 and a half so far as determinants are concerned. And those reflect, we submit, both seriousness and protective elements. In fact, they protect the public by ensuring that they are kept in custody for longer than non-dangerous offenders. They have a longer opportunity to demonstrate that they need to be in custody. But if one wants to view it on the basis of dangerousness plus seriousness, so be it. So there are elements of each of the underpinnings of the sentencing involved in the parliamentary judgments on determinate sentence prisoners.
Is there no explanatory note or statement which throws light on the 2/3?
Well, we haven't found any. There's none in the bundle. We'll look again just to make absolutely certain there's nothing.
And when it was introduced, it seems surprising if no one identified the point.
Can we check again? I'll come back after.
Or just simply explained why it was chosen.
Why it was set.
Yeah.
But the divisional court in this respect were struck by the example of the prisoner who was dangerous by reason of a mental condition. I can see where they were struck by the force of that example. But answer to the unfairness point, if that's what it is that a finding of dangerousness does indeed put the defendant, so far as the overall broad parliamentary judgments that are in play are concerned, into a different category to the non-dangerous prisoner. And the Parliament is entitled, we submit, to treat those sorts of prisoners in a different way. And of course one needs to recognise that if a defendant has a recognised mental disorder, there are other specific packages or sentences that may well be appropriate, including hospital orders. See our case at footnote 75. They're not subjected to any greater punishment at least if one treats the A5 and A7 case law as analogous, because the whole term of a determinate sentence is covered by that punishment or deterrence ground. And so the differentiation is on the ground of combination, if you will, but focused particularly on the dangerousness aspect of it. If that finding is made, as it must be for an EDS to be imposed, that's, we submit, plenty justifiable to require the longer period before you're eligible for release. So we suggest respectfully that there is objective justification with the broad margin that Parliament is entitled to when the comparison is drawn with determinate sentence prisoners. Indeterminate sentence prisoners, again, the composite package we submit is the answer. You can't just ignore the nuances. We know that it doesn't necessarily have to be half on the statute book. There is the opportunity for it to be more if the sentencing court so considers in relation to tariff. But most importantly, the life sentence, if you're doing the comparison between life as an EDS, includes, so far as the life sentence prisoner is concerned, for life, the possibility of recall. Indefinite duration of that sentence, and it means that the prisoner can be detained long after the expiry of the punitive term and remains at risk of detention for the rest of his life. Moreover, there is no prospect for a lifer of automatic release at the end of the determinate term, simply dependent upon the parole board and dangerousness findings. So, for those reasons, and for the reasons that have been relied upon by the courts when choosing which sentence is appropriate, the lifers are not in the same position, and there is an objective justification for the difference that exists in terms of the early release provisions, if you view it as part of the overall package, for the alternative packaging and sentencing regime. The position is, in a nutshell, that Parliament has designed differently structured and special sentences for a particular category or type of offence. And if you want to view it in this way, as I put it to my Lady Black, in return for having automatic release at the end of the determinate period and for not having life licence, 2/3 early release is Parliament's decision. That's how we put it. And that is well within the margin we submit. So we do not accept the characterisation that my learned friend relied upon, and which my lady was in essence putting to me, which is that there is a tension or an anomaly that lower risk prisoners ought to be treated, are they being treated worse than higher risk prisoners, is effectively that. And we respectfully submit that that isn't the right analysis when you view it overall. That's why, for example, in both of those two cases in the supplemental bundle between 6 and 7, the court said, well, hang on a second, you can't turn up and say, well, I'd rather have an extended sentence than a life sentence, because there are those key and fundamental differences. And the early release provisions feed into that, to the extent that there is a difference. And I say there may well not be, because of the legislative treatment and the Rossi case in relation to the setting of the tariff. My lords, those are my submissions.
Thank you very much indeed, Mr. Eady, and thank you for going out of turn with such aplomb, as always. I think your junior is Miss Davidson. Do you follow?
My ladies and my lord, and my lords rather, my submissions essentially will deal with four things. Firstly, I'm going to draw attention to a few features of the domestic legal system, because in my submission it is important not to lose sight of some of those features. Secondly, I'll address the issue of status. Thirdly, analogous situation. And fourthly, differential treatment. But before doing that, can I just make a couple of preliminary points? Firstly, I accept, as my learned friend has mentioned both in writing and orally, that Article 5 and Article 7 of the European Convention don't entitle a determinate prisoner to early release. In principle, it's compatible with both of those articles for a determinate prisoner to be held for every day of their sentence. The reason Article 14 is important is that Article 14 is an additional safeguard that essentially prevents arbitrary distinctions being drawn where additional rights, and early release isn't an additional right, where additional rights are provided domestically. And in this case, it is our domestic system of sentences and early release that gives rise to the issue under Article 14. And there are three features of that system that don't appear to be in dispute that I need to draw attention to. Firstly, as my learned friend indicated orally, and is clear from his statement of case, the first issue for a sentencing court considering imposing a sentence is essentially whether a life sentence should be imposed. By reason of the statute, one can only impose an extended sentence, essentially, if one has ruled out both a life sentence for a second offence and a life sentence for a serious offence. And that's hardly surprising, because the features of the life sentence my learned friend has just emphasised demonstrate that life sentences have the potential to provide the greatest protection for the prisoners who are highest risk. If someone is high risk, one wants to avoid potentially the automatic release, putting them back into the community. Secondly, when imposing life sentences, my learned friend accepts, and I think he's again accepted this orally and in writing, that both seriousness and risk to the public are factors that need to be taken into account. So it's not just about the type of offence. As my learned friend, I think a moment ago, accepted, for example, a life sentence can be necessary in particular circumstances because someone poses a high risk because of their mental health. That's why one can have the situation where one co-defendant receives a life sentence and another co-defendant receives a determinate sentence. So that demonstrates in my submission that some of those who are highest risk, certainly some of those who are equivalent risk to those receiving an extended sentence, will be sentenced to life imprisonment. Extended sentences, and I don't think this is in dispute, are not reserved for the highest risk prisoners. If, with life sentences, one can assume that when they reach their minimum term, which generally is half of the determinate term, there is some possibility of them being released, and release is not necessarily inconsistent with risk management, that means there's no reason why an extended sentence prisoner can't, in principle, be in a position to demonstrate that they can be released with low risk. The third point that's not in dispute is that the minimum term, the penal term, of a prisoner serving a life sentence is normally set at the halfway point. There are exceptional cases, and I'll come on to those, but for a life sentence prisoner, it's quite clear, for the average life sentence prisoner, for the vast majority of life sentence prisoners, it is clear that they will be released, they have a right to be released at half the determinate term if they are sufficiently low risk. That halfway point represents their penalty. Similarly, for normal determinate sentence prisoners, their halfway point is where they have a right to be released. I'll come back in a moment to things like home detention curfew. But they're discretionary schemes. They're not related to risk. One doesn't have a right to be released on home detention curfew. It's at the halfway point in a determinate prisoner's sentence. That's why, in our submission, the Divisional Court, in summary, was correct to say essentially the halfway point of most determinate terms is the penalty. My learned friend is forced, essentially, in his argument, and it's in his written argument, and it's worth noting this point because it does demonstrate how difficult his position is in some senses. Paragraph 77 of his written argument, which is memory stick, page 91. looks at the types of penalties, essentially, for different types of sentences. And it identifies for an indeterminate sentence the penalty correctly as being the minimum term. And for a determinate sentence, standard determinate sentence, we'll ignore EDS for the moment, as being the whole sentence. Now, the logic of that, once one accepts that for most lifers the minimum term is half the determinate sentence, is that for most lifers they are getting half the penalty of a determinate sentence prisoner. That can't, in our submission, be right. If that were right, it would raise very clear issues potentially under Article 14. And the only exception, if one then recognises this point, the only exception where essentially there isn't a right to be released at halfway point, providing one is low risk, is extended sentences. And that is difficult in our submission to justify when, as my learned friend correctly accepted, extended sentences are somewhere between life sentences and determinate sentences. And the points I've just made mean that there is a real potential for unfairness. The Divisional Court highlighted the position of two determinate prisoners, one of whom is higher risk because they have a mental health condition. In those circumstances, they may have exactly the same culpability, and yet the higher risk prisoner, who, as I say, may be higher risk because of mental health, cannot be released at the same point as his co-defendant, whether or not his risk is reduced. Obviously, if his risk hasn't reduced, there may be justification for continuing to hold him. But even if his risk hasn't been reduced, he continues to be held beyond his co-defendant, even if his risk has been reduced, rather. And I give one other example of the potential unfairness that rises, related to lifers. Suppose one has two co-defendants, both of whom pose a significant risk. One perhaps has slightly greater culpability, so gets a life sentence, or perhaps one has a previous offence, so that the automatic life sentence provisions apply. But the differences are not great. The lifer, his determinate term, perhaps reflecting the fact he's got a worse record, the lifer's determinate term would be 14 years. He's eligible for release after 7 years. The extended sentence prisoner, the one who isn't as culpable, their custodial term is 12 years. They can't be released until 8 years. So the prisoner who is most culpable can be released earlier. And my learned friend says, well, don't lose sight of the package. But in Clift, it was individual elements that the European Court of Human Rights focused on, and for good reason, because from a particular prisoner's point of view, they may in fact be low risk when they reach their halfway point. That's why, in some cases, people have been arguing in the Court of Appeal that a life sentence is less harsh, essentially, because they may believe that they are going to be released at their halfway point. And those sorts of differences in our submission are very difficult to justify. And that's the context in which one should consider some of the arguments of my learned friend, particularly the arguments about status. Because ultimately, when we come to status in my submission, what one sees is that the European Court has been, unsurprisingly, very concerned to ensure that there are not arbitrary distinctions drawn as to when people achieve their liberty. The importance of liberty in any human rights system means that it's unsurprising, as I say, that the European Court has focused on the need for Article 14 potentially to apply in this context. Can I then turn very briefly to the domestic system, because there's no real dispute. Can I just draw attention to a couple of features of it? The first is Section 224A of the Criminal Justice Act, which is in Volume 1, Tab 1, which, and it's memory stick page 403, and which sets a provision that essentially allows, or requires, in fact, the imposition of a life sentence for a second serious offence. Now, the reason I draw attention to this is because it demonstrates how, when Parliament is trying to assess the seriousness of an offence, it links half the determinate term, the minimum term essentially, to it links half the determinate term with the minimum term, recognises that they are equivalent. One of the conditions, to put this in context, to explain a little more what I'm saying, if one looks at subsection 1, one of the conditions that must be met before this duty arises to impose a second life sentence is what's described as the previous offence condition. If one goes to subsection 4, one sees the previous offence condition has two elements. One, the offence has to be of a particular nature. Second, it has to be one that attracted a sentence of sufficient severity, presumably as some mark of how serious the previous offence was. One sees that in subsection 5, life sentences are measured, the threshold rather for life sentences is 5 years. For extended sentences, it is 10 years. The custodial term is 10 years. And for determinate sentences, the custodial term is 10 years. So Parliament, aware we would submit of sentencing practice, is indicating effectively that when trying to measure seriousness of offending by the penalty imposed, half the determinate term is essentially equivalent to the minimum term. Sorry. The second feature of the domestic legislation that I'll draw attention to very briefly, where a life sentence is to be imposed for a serious offence under section 225, there are essentially two relevant conditions that need to be met. The first is under subsection 1b, which is the requirement that there is a significant risk to members of the public. And secondly, the seriousness of the offence must justify life imprisonment. Now, that is important in my submission because when one then goes to section 226A, one sees essentially, which is the provision that governs extended sentences, which is at page 407, memory stick. One sees the same requirement for a significant risk in subsection 1b. But before one can impose it, one has to have ruled out a sentence of imprisonment for life by reason of subsection C. So an extended sentence essentially is imposed in circumstances where the prisoner is of equivalent risk to a prisoner who would receive a life sentence, but their offending is less serious, and so they don't justify a life sentence. The extended sentence is then clearly intended to address that risk, because if one goes to subsection 5 and subsection 7, one sees the difference between essentially the custodial, between an extended sentence and a normal determinate sentence, is that there is this additional period of license extension, and the license extension is meant to manage risk. And that's important in my submission because it links back to the point my learned friend said, which is essentially extended sentences are between normal determinate sentences and life sentences. Prisoners who are high risk and commit the most serious offences receive a life sentence. but they're not required to be held until to the 2/3 point. Prisoners who are still a risk but commit less serious offences, Parliament's indicated need special provision to manage that risk, but for some reason that minimum period of custody is increased. And that is where there is a real problem in our submission with the system. Now, I've already referred to the provisions in the Act that link the minimum term to the halfway point. My learned friend has drawn attention to case law that also makes it clear there is a linkage. Rossi, I should say, as far as anyone's aware, certainly as far as we're aware on our side, is the only case where essentially the seriousness of the offending caused the Court of Appeal to depart from the halfway point. Caserba is the authority that was cited in Rossi. It's at volume 2, tab 23. And is generally sort of regarded as, or is generally cited as the authority for the proposition that halfway point is normally the minimum term. And that's of some importance because it gives some indication of why the Court of Appeal have generally departed from the halfway point. It's at Memory Stick 1040, and as I say, it's volume 2, tab 23. One sees at paragraph 33 that the examples the court gave where there was a need to depart from the halfway point were essentially cases where, because one can't have a consecutive life sentence, the minimum term needed to be increased to take account of the fact that the prisoner was already in custody for other reasons. Now, one can see there might be a need to depart from the halfway point. All one is essentially doing then is imposing what ultimately amounts to a consecutive sentence, with the real minimum term being the halfway point. And Rossi is the one exception to that. Rossi, in my submission, doesn't take my learned friend very much further. Firstly, because there is no discretion, essentially, to disapply the 2/3 rule. One doesn't have to, before applying the 2/3 rule, identify some exceptional circumstance. Secondly, there wouldn't be an Article 14 argument if extended sentences were treated more favourably, because, as my learned friend accepts, they come somewhere between lifers and determinate sentences. Thirdly, I would put a question mark over Rossi, because in some senses what Rossi is doing is increasing essentially the penalty because of the fact that there was a very serious previous record. But when setting the determinate sentence, if somebody's got a previous criminal record that is particularly serious, one would increase the penalty. So it's a little unclear why there needed to be a further increase in the penalty because of the fact a life sentence was being imposed. So we do submit that the domestic system is clear. It recognises that in general there is a right to release on risk grounds at the halfway point of a determinate sentence. Extended sentences, as my learned friend accepts, fit in the middle between life sentences and determinate sentences, and yet extended sentences are the one situation where there is this automatic rule that one is held to the 2/3 point. Can I then turn to the issue of status? Can I start by saying it's important not to lose sight when looking at status in this context, that this is a context where the House of Lords in Clift essentially indicated that it was merely a concern about keeping in pace with Strasbourg, essentially, that caused it essentially to conclude that there wasn't a relevant status in Clift. The issue in that case, we would submit, is very analogous. It was a situation where the distinctions were between types of sentence. They were between the sentence or between, the distinctions drawn were between people serving life sentences, prisoners serving determinate sentences of over 15 years, and other determinate sentences. And if one turns to Volume 1, Tab 2, the relevant passage is paragraph 28, page 623. One sees Lord Bingham was sympathetic, essentially, to the argument that a life sentence or a sentence of over 15 years was a status, essentially. His primary reason, or his only real reason, for concluding it wasn't a status was he didn't think Strasbourg had gone that far. That's important when one considers, for example, the arguments about whether or not treatment can define the status. My learned friend points to the fact that Lord Bingham indicated that treatment couldn't define the status, as did Lord Hope. And there may well be an interesting issue, interesting argument about whether Clift went too far in relation to that. But clearly both Lord Bingham and Lord Hope, who adopted a very similar approach, essentially, of being concerned about the approach of Strasbourg, didn't think that was a reason why the type of sentence, essentially, was not a status for the purposes of the Convention. If one goes to paragraph 49, one sees Lord Hope, essentially, reaching a similar conclusion to Lord Bingham, essentially, that the court shouldn't go beyond what has been decided by the European Court of Human Rights.
Can you just help me as to what was the provision which was under attack?
Provision under attack in Clift was that if you were a lifer,
Which particular provision? Was it the parole board transfer?
No, it was who was responsible for deciding on release.
Yes.
Sorry, under which section? Because they're set out at paragraph 3.
Sorry, can I come back to that, given it's almost like...
I just want to identify the particular provision which it was that distinguished between those who had done their 15 years, those who were subject to 15 years and those who weren't.
It was...
One is mandatory and the others may.
Yes, can I come back to it?
Yes.
Yeah, yes, if I may, I'll come back to it. My Lady Baroness Hale went perhaps slightly further. If one goes to paragraph 62...
Further than whom?
Than Lord Bingham and Lord...
And in which direction?
Yes, it's a fair question. Or perhaps sort of in terms of identifying a reason why the sort of nature of the sentence wasn't a status, in that my lady indicated essentially at paragraph 62, the last two sentences, essentially that it was the seriousness of the seriousness of the offence, essentially, would take one outside the scope of Article 14. But of course, in this case, one's not looking at the seriousness of the offence because, as I've already indicated, co-defendants may be treated completely differently because of the risk they pose.
Well, that was why I was putting to Mr. Eadie.
Yes.
Isn't the distinguishing feature why you get this sentence rather than
Yes.
what would otherwise be the appropriate determinate term, the fact that you've been adjudged to be dangerous?
Yes. Yes. Well, that's quite clear. That quite clearly influenced the European Court of Human Rights. I was going to go to the European Court of Human Rights, but I'm conscious it's 1 o'clock, so...
That seems a suitable point at which to pause.
Thank you.
Thank you very much indeed. We look forward to hearing from you further at 2 o'clock. Court will now adjourn.